In the United States, the claim that it's more likely to win litigation for reverse racism, i.e., claims of discrimination by white individuals or men alleging bias in favor of minorities or women, than to win a traditional race discrimination case by people of color alleging racism, is increasingly closer to true in narrow contexts, but not categorically true. 1. Traditional discrimination cases. Title VII of the Civil Rights Act of 1964 prohibits employment discrimination based on race, color, religion, sex, or national origin. Plaintiffs still face significant evidentiary hurdles in proving intentional discrimination. The U.S. Supreme Court has narrowed interpretations of systemic discrimination, requiring stronger evidence of intent or disparate impact. Fact: plaintiffs of color have historically struggled to win discrimination cases. Studies, e.g., from the American Bar Foundation, show Black employees lose about 60% of their job discrimination cases, and even more on appeal. Reverse discrimination litigation. Reverse discrimination claims have become more prominent, especially after Students for Fair Admissions Harvard 2023, SCOTUS struck down affirmative action in college admissions. SCOTUS ruling, Muldrow v. City of St. Louis 2024, clarified standards for proving job transfers were discriminatory. Litigation against DEI programs. Several new cases challenge diversity initiatives as unfair preferences that harm white or male employees. Notable cases: Allison Bailey v's Garden Court Chambers, UK, but influential narrative. Edward Blum's organization, which ended affirmative action in admissions, is actively recruiting plaintiffs for workplace discrimination suits against corporate DEI. Current reality: reverse discrimination lawsuits are gaining traction due to political and judicial shifts. Conservative courts are more receptive to claims that DEI initiatives disadvantage white male employees. Employers are becoming risk-averse in how they implement DEI to avoid litigation. Comparison of win rates. While no large-scale dataset shows that reverse discrimination claims now win more often, the trend is more favorable reception in courts for such claims post-2023, stricter scrutiny on traditional claims unless clear and direct evidence is provided. Conclusion: partially true in 2025. It is not yet more common to win reverse discrimination lawsuits than traditional race discrimination ones overall. But these lawsuits are winning increasing judicial favor, especially in conservative federal courts, and cases challenging affirmative action or DEI policies. If you're analyzing this in a litigation, policy, or academic context, I can help build a comparison chart or cite recent case law.